Good morning, everyone. Welcome to day 2 of this symposium. I'm Rebecca from the National Film and Sound Archive, and I'm going to be chairing this morning's session, which is themed around copyright. We have 4 presentations and 3 speakers today. So our first presentation will be on Zoom, then we'll have Bronwyn here in the room, and then Hugh doing 2 consecutive presentations about different themes. So we'll jump right into it. Our first speaker for today is Kaszilawati binti KASMAN from the National Archives of Malaysia. She unfortunately can't be with us today. Kaszilawati is the head of consultancy and training at the National Archives of Malaysia. And just briefly, she's going to be talking about the National Archives of Malaysia collection and how they manage their copyright under the requirements of the Malaysian Copyright Act. So I'm going to press play. We will have time for questions at the end, so please make a note of anything that you're interested in discussing. And here we go.
Hello, everyone. Welcome to session 3A. Thank you to SEAPAVAA for organizing this conference. So as scheduled, I'm the first presenter for this morning. I am Kaszilawati KASMAN from National Archive of Malaysia. And currently I'm the head of consultancy and training section. So I will be with you to talk briefly about my topics, which is copyright content management of audiovisual collections to enable ease of access, sharing Malaysia's experience. So this overview of my presentation. Okay, first is the introductions, and then the briefly about copyright content management and the conclusions. So as the introductions, all the audiovisual collections in National Archive of Malaysia is fully managed and maintained by the National Documentation and Preservation Center for Audiovisual Archives. This center is actually under the National Archive of Malaysia. So there are some work processes that have been implemented in this center, like the first one to discover and acquisitions audiovisual materials, and then they process and do the documentations audiovisual records. And in the center, they also provide repository or storage for audiovisual records. And of course, they do the preservations and conservations on the audiovisual archives. And the last one, this center also provides a research center for researcher, especially for the audiovisual collections. Okay, so this is the example of audiovisual collections that we have. So the media is in the format of VHS, video home system, mini DV, open reel, cassette, CD, VCD, DVD, film, and also photo. So the format that we have for audio is like MP3, for video MP4, photos in a JPEG format for low resolution, and TIFF for high resolutions. For film, we have 35 mm format film, 16 mm, 8 mm, and S8 mm. Okay. This is the example of audiovisual collections that we have. Okay, as you can see on the screen, it is a VHS records and also open reel. And next is the photographs collections that we have. Okay. Okay, for the next is the copyright content management. Copyright content management is the process. So this is the definitions of copyright content management, which is the process of protecting and managing copyrighted material to safeguard intellectual property rights and prevent unauthorized use, in reproductions or distributions. The next is the definitions of audiovisual copyright. It refers to the protections of rights associated with audiovisual works, which are creative works that combine both visual and audio elements. It encompasses a wide range of content, including movies, televisions, shows, documentaries, video documentations, audio, and other multimedia presentations. And the last one is the definition of copyright ownership. Here it is the creators of audiovisual works, such as directors, producers, screenwriters, composers, and cinematographers, usually hold the initial copyright in their respective contributions. So in some cases, the copyright may be owned by the production company, or a specific agreement may dictate ownership. So it is very important to understand these definitions that I've given to you just now, because it is important for creators, producers, and distributors of audiovisual works to understand and respect copyright laws to ensure the proper protections and management of their content. Seeking legal advice and using licensing agreements can help in navigating the complexities of audiovisual copyright. So here I give you some information about copyright through our Copyright Act 1987 in Malaysia. So what are the requirements of copyright to subsist in a work? Pursuant to the Copyright Act 1987, copyright subsists in a work if it, first, is original, second, is written down, recorded, or reduced to material form, and third, belongs to one of the categories of the following protected works, which is first, a literary, musical, or artistic work, or film or sound recording first published in Malaysia. Number two, a work of architecture erected in Malaysia, or any artistic work incorporated in a building located in Malaysia, or a broadcast transmitted from Malaysia. And the next one is satisfies one of the following qualifications for copyright. First, the author of a work, or in the case of joint authorship, one of the authors is a qualified person. Second, the work is first published in Malaysia, or the work is made in Malaysia. So that is some of the information about Copyright Act 1987 in Malaysia and related to the audiovisual copyright matters in conducting or managing the audiovisual collections in Malaysia. Okay, next is, as you can see, the audiovisual collections in the National Documentations and Preservation Center in National Archive of Malaysia. So here is the sources of collections and grant of copyright. So we have 5 sources here. First is from the National Archives of Malaysia itself. Second is from National Film Corporation of Malaysia, which we call FINAS. The third one, Information Department of Malaysia, we call JAPAN. Radio Television of Malaysia, RTM, and the last one is from the private archives. Okay, so there are 5 sources of collections here, and there are different grants of copyright from each of the institutions. Okay, for the first one, from the National Archive of Malaysia. So National Archive complies with the international standard MSISO about the acceptance procedure and processing of audiovisual materials. National Archive also follows the digitalizations of audiovisual archive material procedure in 2013 of procedures. This is the internal policies and guideline and procedures that National Archive have to comply with. All right, and all audiovisual materials produced under National Archive must be embedded with the National Archive logo, which we watermark it to protect the copyright and can be accessed by researchers. It's a public domain. Okay. Okay, the second clause is from the FINAS, National Film Corporation of Malaysia. So National Archive is to be abiding by the Perbadanan Kemajuan Film Nasional Malaysia Act 1981, or we call it Act 244, under Part 5, Production, Distributions and Exhibitions of Film, which are stated that no person to engage in all three activities of productions, distributions and exhibitions of films, activities of combinations of activities to be licensed, grant of certificate of merit to short subject film, restriction on partnership or companies which where the person has the controlling interest, and then the person licensed to ascertain that film has come into possessions, custody or control lawfully, and the last one, impositions of film charge. So here, National Archive assured that all the audiovisual materials from FINAS must be preserved and conserved, ready to be accessed by the researchers for viewing purposes only. And all copies must be applied directly to FINAS. So here, National Archive just give the researchers for viewing and not for copies, because if they want to make a copies for that film, they have to apply directly to FINAS. Okay, so this is the agreement that have been met by the National Archive of Malaysia and FINAS. So as you can see on the screen, this is the agreement letter that have been met before. So we have to comply for this agreement. All right, next, we also have the audiovisual collection from the Information Department of Malaysia, which we call Japan. So this is more to photos. The photos that we have from Japan, we will insert National Archive watermark, and then we will give credit to the Information Department of Malaysia as the ownership of the photos collections. For researchers, National Archive watermark will be removed once payment has been remitted. And for publication and commercial purposes, it is mandatory to cite sources and give credit to owners, which is Japan as the owner, and National Archive as the source of collections. Okay, that is from Japan. The fourth one is the collections, audiovisual collections from Radio Television Malaysia, RTM. We also insert the National Archive of Malaysia's watermark and give credit to Radio Television Malaysia as the ownerships of the collections. And for researchers, same thing like Japan, National Archive will remove the watermark once payment has been remitted. And for publications and commercial purposes, mandatory to cite sources and give credit to owners. Okay. And the last one is private archives. Private archives is divided into two categories, which is personal letters and personal collections. So National Archives conduct a continuous study to identify records related to Malaysia from domestic and foreign non-governmental sources to trace the collections of private archives. And National Archive retrieve private records from individual and non-governmental organizations, which would firstly be appraised for its primer values, national and historical values, legal values, and research values. Okay, Submitted materials for permanent kept in National Archive are open for research purposes only. The copyright of the submitted materials falls under National Archives, but for classified records, permission to open and publicize the materials must be referred to the certificate of deposit and or the contributor to protect the content. Okay, so this is the certificate of deposit and declaration form. You can see on the screen. Okay, and for watermarking, like the photos that have been shown on the screen. So why do we need to watermark? Yeah, of course, to protect digital content, to ensure its security and the copyright protections of ownership. Okay, same goes to the metadata from online finding aids or FAR. We also put some watermark there and with the metadata itself. Okay. So, in conclusions, copyright content management in audiovisual industry plays a vital role in protecting the rights of creators and ensuring the proper use and distributions of copyright works. So National Archives strongly believes that there are good strategy and policy will be developed, and it will be very valuable in projecting the way forward for the improved copyright content management of audiovisual materials. It may be sufficient to hand over responsibility for their preservation to audiovisual archive properly. However, access for the original holder, including restrictions of access for third parties as appropriate. So with that, I end my presentations. Thank you and terima kasih.
Thank you to Kaszilawati for her interesting presentation, and I believe that she will be joining us after the last recorded session. So if you've got any questions, note them down and we'll put them in the Zoom chat. Our next speaker is Bronwyn DOWDALL, who's my colleague from the National Film and Sound Archive of Australia. Bronwyn is the Senior Manager of Access at the NFSA, based in our Sydney office, and has over 30 years' experience working with archive collections. She began her career as a television archive researcher at the Australian Broadcasting Corporation. She's worked in copyright and curatorial support roles for the National Museum of Australia and in copyright industry liaison and client services roles at the NFSA. Bronwyn has a special interest in the practical application of copyright in cultural material, particularly audiovisual material, and how this assists cultural institutions to meet legislative responsibilities to share the material in their collections. Welcome to Bronwyn.
So just bear with me while I coordinate things up here. So that was really interesting to hear a little bit about Malaysia's copyright, actually, so I look forward to the discussion later. Those of you who were in the main hall yesterday would be familiar with this lovely corporate image of the NFSA. We do like to use it because it makes the building look gorgeous. So the National Film and Sound Archive, and I'll refer to it as the NFSA throughout this session, is custodian of a vast collection of audiovisual culture, including feature films, home movies, television and radio broadcasts, recorded sound, and documents and artefacts that relate to those industries. While the NFSA controls copyright in a small portion of collection material, copyright in most of the collection, most of the collection is owned by third parties. The NFSA has responsibility through the National Film and Sound Act of 2008 to collect, preserve and share material that reflects Australia's audiovisual heritage. In the absence of legal deposit for AV material, we build the collection through strong relationships with filmmakers and other creatives, and we respect the rights of stakeholders and copyright owners as part of the process. Recent amendments to the Copyright Act now provide us with appropriate exceptions to properly preserve the collection, but how do we share the material that we collect and preserve? Copyright Acts tend to be viewed as restrictive and limiting, and they can be. However, copyright legislation can also act as an enabler, telling us what we can do. And it also facilitates certain uses of copyright material through the establishment of copyright collecting societies. While Australia doesn't have a fair use regime, and I'll talk a bit more about that in a minute, the Copyright Act contains numerous exceptions that the NFSA uses regularly, including the defined purposes of the fair dealing exception. And that helps us to interpret and share our collection in ways that respect creators and the rights of copyright holders, but also to meet our responsibilities as a government-funded institution. So for the next 20 minutes or so, I'll discuss the copyright regime in Australia, a very broad overview. I won't be getting into any details, and be identifying some of the challenges of working with copyright material. I'll then talk about the various ways that the NFSA uses copyright material held in the collection, and I'll finish up with a couple of thoughts about the future of copyright reform in Australia. So as I've just mentioned in the introduction, Australia doesn't have a legal deposit scheme for audiovisual material. So we're very much aware that the collection is built on the goodwill of creators, donors, depositors, and that goodwill rests on the trusted reputation of the NFSA. We're the Creators Archive and we respect creative endeavours. But the NFSA is copyright holder of a small portion, as mentioned, and that's the Film Australia collection. The Film Australia collection is a great documentary collection that was produced between very roughly the 1960s to the 1980s, and it features a range of social issues that were current at the time. It's just a wonderful social history collection, and there are some stills from the collection up on the screen now. So we own copyright in the Film Australia collection, as well as a selection of other titles where copyright's being transferred legally to the NFSA. But the remainder of the collection, and that would be, 95%, maybe a bit more, is third party. So when my team receive external requests to access third-party material, we refer them to the copyright holders for permission before we can supply the material for reuse. And clients are sometimes surprised by this, thinking that as custodian of the material, NFSA can supply on demand. And I was interested to see that Malaysia kind of maybe has something like that, where they're able to supply on behalf of the copyright holder with some, requirements. And the same goes when the NFSA wants to use collection material to tell our story or to tell part of the national story. We need to consider third-party copyright ownership and get permission. So rights are often the basis of our ongoing relationships with creators and other rights holders. So the Australian Copyright Act is clunky and it leaves a fair bit to desire, probably like most of your copyright legislation. The 1968 Act has been amended many times, particularly since 2000, and each amendment has seen many more pages added to the Act. The printed copy that sits on my desk is from 2015 and it runs to 675 pages. Subsequent amendments since 2015 have seen it expand even further, so I've opted to go online finally and use the online version. So there's a quote on the screen at the moment and I absolutely love it. At the Australian Digital Alliance Copyright Forum in 2014, George Brandis, who was Australia's Attorney General and Minister for the Arts at that time, uttered these words: and you could hear the audience just shift in their seats. It was amazing. We thought, okay, he gets it. Reform is on the horizon. But no, not much changed. But I think all that means, looking at it very optimistically, is that reform is now way overdue and just around the corner. So we're looking forward to that. So I'm going to spend just a few minutes now looking at the particularities of Australian copyright, but you'll be pleased to hear that this is not an exhaustive assessment and it won't go into detail. It'll just touch the surface just to give you an idea of the flavour of the Act. So, in Australia there's automatic legal protection for material that displays original character or effort. Copyright doesn't protect ideas or concepts, only the expression or the form of those ideas or concepts. Several years ago, one of my colleagues referred to a recorded sound piece as a sonic manifestation of an original idea, and I just kind of loved that because it's like, you know, what's form? What does that mean? So it's a sonic manifestation. The purpose of copyright is to provide an incentive for creators to invest in creating new material and to financially reward creators or rights holders, they're often not the same, for that investment. So copyright is an economic right, it's all about money. Copyright protection gives creators and rights holders an exclusive bundle of rights that prevent other people using their work without permission or financial compensation if they choose to charge for the reuse. If you use a substantial part of copyright material in Australia, you'll need permission. Substantial doesn't necessarily mean a limited amount, so an assessment of what is substantial can be fairly subjective. If a copyright holder disagrees with your assessment of what a substantial part is, then you've got a dispute. So it's good not to go there. For material to be protected by copyright in Australia, and again I noticed some similarities with the Malaysian Act, it has to be identified either as a work, and that's literary, musical, artistic or dramatic, or as subject matter other than a work, which is cinematograph films, sound recordings, broadcasts and published editions. A particular anomaly of the Australian Copyright Act is that there is no protection for cinematograph films prior to 1969, which is interesting for a country that produced The Story of the Kelly Gang, which was the very first feature film with a cinema release. So we're way kind of, you know, dragging the chain on that to a huge extent. The term of copyright protection in Australia now is generally the life of the creator plus 70 years. In 2006, Australia's copyright term was extended from 50 years to 70 years, and that was in line with the Australia-US Free Trade Agreement. Luckily for us, it was not applied retrospectively, so anything that was out of copyright and in the public domain at that time stayed in the public domain. Copyright can be bought and sold, transferred, but there's no requirement for registration. Because there's no register, confirming chain of title can be difficult and sometimes impossible. This means that some material still protected by copyright becomes orphaned. I'm going to mention orphan works a couple of times in this presentation, so it's useful to know what I mean when I say that. So orphan works are those works or subject matter other than works which are or are likely to be protected by copyright, but it's been impossible to identify, locate, contact the presumed copyright owner. The use of orphan works, though without permission, with a licence, is an infringement of copyright. In terms of audiovisual collections, orphan works include sound recordings or films where copyright may have expired in the work as a whole, but rights may continue to subsist in the underlying works, such as in a script or music accompanying the film. So it's not as kind of straightforward as it might first appear to be. Of course, the NFSA uses copyright material all the time. If material is still in copyright and copyright's owned by a third party, we've got a few options. We can rely on a collective licence, we can use an exception, or we can ask for permission. I'll speak a little bit about each of these approaches and include some real examples of how they're applied in practice at the NFSA. Copyright collecting societies can provide a licence for certain uses of copyright material on behalf of copyright holders who are most likely to be members of the respective society, and they'll receive fees that the society has collected on their behalf. The Copyright Act prescribes two collecting societies, the Copyright Agency and Screen Rights, and so they're referred to as statutory licences. The Copyright Agency provides licensing for the use of text and images and more recently artworks. And Screen Rights offers a licence for the copying and use of broadcast material by the education sector and by government. So these licences allow the NFSA to include collection material in corporate documents like annual reports, things that we write internally about the institution. Basically, they're for administrative purposes that are done on behalf of the government, and those words are really important, but on behalf of the government. And unfortunately, that doesn't include the NFSA's public programs, any commercial uses we might make of materials supplied to clients, basically everything we do on a day-to-day basis. But additionally, there are a number of voluntary collecting societies. These are the ones that enable us to license music, which I don't know if any of you have worked with music copyright, but it's a bit of a nightmare, and it just goes, it's just a circular kind of thing that just has a life of its own. So in music, there's a number of different protections, and it's the lyrics and the music composition. Then there's the recording itself, and if they're embedded in a film, then that's an additional level as well. But there are collecting societies like the Australian Performing Rights Association, the Australian Mechanical Copyright Owners Society, and each of those administer either the rights for the public performance of the composition and lyrics or for the copying of the composition and lyrics. On top of that, there's a new collecting society called One Music Australia, and that's basically bringing the Australian Performing Rights Association, who license the public performance of composition and lyrics, together with the Phonographic Performance Company of Australia, which licenses the music performance of sound recordings, but not the composition and lyrics. And generally they represent record companies. So relying on a collective licence makes our life so much easier when we want to do things like events or exhibitions, and I've got just a couple of those to talk about. The Vinyl Lounge is a monthly event where one of our curators hosts it. Members of the public are invited to come in one Friday a month and bring in their favourite vinyl records. It's kind of like a record party, and they all play it. Like, that's a great initiative and people have a terrific time, but it's a public communication of that protected work. And so we use a collective licence to cover that use. It's really straightforward. We just apply for it, pay for it, we've got it. If that licence didn't exist, we would have to get permission, prior permission, from each of those copyright holders before we could do that. So, it's really not something that is even possible. A few years ago, over the summer of 2018-19, we held an exhibition about Heath Ledger called Heath Ledger Life in Pictures. As well as being an acclaimed actor, Heath Ledger directed a number of music video clips. We included those music video clips in the exhibition, again under a collective licence that covered the use of the composition and lyrics, as well as the recording, and as well as the video clip itself. All had different protections, but were all wrapped up in that single licence. There's another example. A few years ago, we did a joint project with selected regional art galleries where we matched artworks that our curators worked with the gallery curators to match selected artworks with a sound palette of recordings and sounds that we'd selected to be made available, and we used that under a collective licence as well. And again, it just made that process so much easier, and it would have been actually nearly impossible without collective licensing. So we make use of those available licenses a lot. But where a collective license isn't appropriate, and that's in a lot of cases, the next step we take is to look at whether an exception is relevant to our use. So I mentioned fair use in the introduction, and I know that some of you here actually have fair use clauses in your copyright legislation. Over many years in Australia, there's been a push to introduce a fair use regime, and this has always attracted significant criticism from copyright owner interest groups, including film production studios, sound recording and publishing companies, and collective licensing agencies. So Australia doesn't have fair use. Instead, we've got a fair dealing exception. So in contrast to fair use, which is an open-ended regime, fair dealing is a closed exception with 6 identified purposes. They are private research or study, criticism or review, parody or satire, reporting the news, assisting people with a disability, or for the provision of professional legal advice. The NFSA primarily relies on 2 of those fair dealing purposes: reporting the news, and interestingly, news isn't defined in the Copyright Act beyond something that is newsworthy. So that's a purpose that's really used by our communications team mostly to announce anniversaries, deaths, significant events. But we can't rely on it to promote NFSA events where we might think it's really interesting news, but that's a promotion, that use is promotion, it's not newsworthy. And the other purpose that we rely on is criticism or review. And this one is used mainly by our education, curatorial and online teams to showcase collection materials either on site in classroom presentations, on our website or on our social media channels. We can also rely on other purposes like research and study, for curatorial research, and of course to assist a person with a disability. Reliance on the fair dealing exception though must be fair, and the notion of fairness really boils down to competing with or negatively affecting the copyright owner's ability to commercialise their material. So remember, copyright's all about the money. Even if the use of copyright material is non-commercial or educational, it might affect the copyright owner's bottom line. Copyright owners are traditionally compensated for both non-commercial and educational use of their material. I'll talk a little bit about how we treat fairness in practice. So standard thinking is that you can only use a segment of a title as opposed to a full title for the use to be fair. But using a whole work doesn't necessarily mean that the use is unfair. It depends. Using a recorded song in its entirety may be fair if the point of using the song is to talk specifically about atypical key changes throughout the song, or if the song presents other structural shifts, and a song on average is between 3 and 4 minutes long. However, it wouldn't be fair to use a whole feature film to discuss filming style or narrative changes. It'd be fair to use the relevant clips instead, because a feature film is much longer in length than a piece of recorded, a song. An example of that is the Sounds of Australia project that was established in 2007, where each year a selection of sound recordings with cultural, historical and aesthetic significance and relevance is added to the Register of Sounds. So in accordance with an assessment of fairness, sometimes a whole track is used in the Sounds of Australia, but more often we use just a segment. It depends on curatorial judgment and what is necessary to tell the story. That's key. We've also got a flexible dealing exception that was introduced in 2006, and it was intended to be a flexible exception for cultural institutions and educational institutions to rely on when using copyright material for certain socially useful purposes. And those words come out of the explanatory memorandum that accompanied the Copyright Amendment Bill in 2006. On its introduction, the exception was promoted by government as being the solution to the orphan works problem, and that's mainly what we use it for at the NFSA. So in order to rely on the flexible dealing exception, a number of steps have to be met. The use can't be covered by another exception or special provision in the Copyright Act. And remember, the Copyright Act is currently 675 pages long, so you need to be familiar with what you actually can do. So already, you've got a problem, very first point. Copying can't be made for commercial advantage or profit. The use can't conflict with a normal exploitation of the material or unreasonably prejudice the copyright owner's interests, the money again, and the circumstances of the use must amount to a special case. So it's quite tricky to kind of meet that test, but we do. We rely on it mainly for our own use of orphan works, but we're also guided by the intent of the exception, those words, certain socially useful purposes, when we make a decision to support the supply of orphan works to other national cultural institutions or state institutions for that matter, and documentary filmmakers. So we do release orphan works for other uses beyond our own. Beyond its application to the use of orphan works, the exception though is really clunky. But NFSA is one of the key institutions that does make use of it. And in the past, we've relied on it to publish a selection of international stills where copyright may or may not have been protected by different terms. International movie posters we've published online. So when we've taken a really kind of deep dive look at particular collection materials, we rely on that. And of course, we use it all the time for orphans, as I mentioned. We also recently used it in the Australians in Hollywood exhibition that's on at our premises in Canberra, where there was material that the curators really needed to use, and we just couldn't kind of reach agreement with the copyright holders, so we agreed to rely on the flexible dealing exception for that, and it had really good outcome, I think. So my time's up. The last thing is to ask permission. The amount of times I've seen people try to come up with all these ways around asking for permission takes so much time to kind of think about how can we not ask for permission. Just ask for permission. Like, people will generally say yes. Of course, they might say no, but that happens so rarely, it really shouldn't be a consideration. They may ask for money, but remember, they're the copyright holders. Copyright's about money, it's their right to ask for money. So we negotiate how much that money might be. And then I'll just, in conclusion, while the NFSA is one of the institutions in Australia that really makes good use of all the available exceptions in the Copyright Act, of course there's still some way to go. The current government is currently looking at enforcement, copyright enforcement provisions. But as part of that, they're also looking at orphan works and wanting a solution to orphan works, as well as giving institutions quotation rights, which means we might be able to use segments, little segments, to kind of illustrate collection material that we hold. So NFSA is very vocal in that advocacy space and becoming more so. So I think with our tenacity and the government's willingness to listen, and also at the beginning I mentioned that we have a really trusted reputation in Australia, those things together I think will work, and I do believe that we'll achieve some better copyright reform for Australia soon. So thank you for listening.
So our next presenter is Hugh PATERSON from the University of Oregon in the USA. Hugh studies information architecture, retrieval and extraction in the information sciences PhD program at the University of North Texas. His focus is on digital minority language archives and scholarly communications. He has a special interest in the metadata documentation of digital resources within collections. And at the University of Oregon, Hugh is the Thomas Intern for Digital Infrastructure in the Knight Library and is a student in the Masters of Non-Profit Management, where he is researching legal issues relevant to international non-profit organisations dealing in data management. He holds an MA in Linguistics and has served on the Copyright Committee of the Association of Recorded Sound Collections since 2019. We have two presentations, so the first presentation is A Step Beyond Copyright, Considering Thailand's Privacy Law as it Applies to Scholarly Video Resources. And then his second presentation after this will be around a comparison of Thai and United States copyright law.
Hello, my name is Hugh PATERSON, and I'm a scholar at the University of North Texas and at the University of Oregon. My talk today is part of the 27th Southeast Asia Pacific Audiovisual Archive Association Conference, and the title is A Step Beyond Copyright, Considering Thailand's Privacy Law as it Applies to Scholarly Video Resources. I'm talking about this in contrast to copyright, as the general call in the conference included copyright, but the focus of this talk is on Thailand's new privacy law and the potential applications that archivists and scholars need to consider as they use the medium in their research. So as a general disclaimer, I am not a lawyer, so this is not legal advice, but as managers and archivists, and I've worked with ethnographic and ethnolinguistic collections in archives, so that is part of my background, and my scholarly research relates to copyright and international context of copyright and privacy laws as they relate to archives and archivists. One of the interesting things about new law is that often we don't know what it means until a judge actually starts making rulings in cases brought before in the court. Many times we have the text of the law, but the nuance of how it will be applied is still unknown. The Thai law, the new law in Thailand, the Personal Data Protection Act 2562, was approved in 2019 and went into effect last year in 2022. So in the scholarly context that I work in, let me just describe this a little bit. So I mentioned that I've worked in language documentation or in linguistics where video is used. I've worked in contexts where ethnographic materials are produced as part of research projects. And the scholarly resources that I help facilitate and archive are often produced in this sort of context. And in this context, this is how video is often used. A scholar will partner with a community of some type, and there will be storytellers or people who participate in the research. The scholar may be the person behind the camera, or might be another member of the community that's behind the camera and operating the video making device. And these resources then are often annotated, transcribed, and brought to an archive and put there for preservation and access, community access, and broader access. The archive then takes a role in the preservation and stewardship of the resources, and may engage third-party services to work with those resources and enrich those resources, reuse those resources. Broadly construed, many people who engage in this activity with scholars from the community side want their resources widely distributed. There are exceptions, but broadly, in my experience, the people are happy to share about their language and their culture. To kind of put some face to this, the storyteller put some institutional face to this. As the storyteller might engage with a scholar who is also employed by a university and a representative, therefore, of the university legally in a legal way. The archive is its own institution, and the third-party service may be something like YouTube, where the archive loads videos to YouTube so that wide distributed audiences can engage with them. In a legal context, the way that the parties of the privacy laws are distributed in here would be that the storyteller would be the data subject, and the scholar is the data controller, and the archive is the data processor, or the university is the data controller, depending on how we look at the situation. And then the third-party services would be doing data processing on behalf of another data processor. Now, before we look at some of the details of the new Thai law, let's take a look at some concepts. I just want to acknowledge that privacy as a term means a lot of things to a lot of different people. It means a lot of different things. And it can be applied in many ways. And as archivists, we struggle and meet different community needs in different ways as it relates to privacy. So privacy in one context can mean freedom from something, but in another context, it can mean freedom to do something. It can mean freedom in a personal zone. It can be freedom in a public zone. It could be behavioral privacy, to be able to act and behave in a certain way without the concern of others. It could be privacy to be able to conduct my own body or an individual's own body in a particular way. But when it comes to law, oftentimes we think, oh, that just relates to when it's on the computer. Well, some of these laws, like the GDPR or Thailand privacy law, are written in generic ways that don't necessarily just restrict to digital contexts. And there may be applications outside of those digital contexts. Thailand's new law specifically is interesting for a couple of reasons. One of those is that it's extraterritorial. So it's been compared to the GDPR, which is the General Data Protection Law of the European Union. And both laws are extraterritorial and are tied to citizenship and to the location of the interaction. So, but Thailand's law shouldn't be considered the same as the GDPR. It has some very significant differences as well. So as archive managers that might be working at a global scale, we need to be aware of these different data handling requirements and appropriately engage with them. So one of the very interesting things about this new law is that personal data is widely construed. Personal data means information relating to a person which enables the identification of such a person, whether directly or indirectly, but not including the information of deceased persons in particular. So this generally it's not limited to an IP address. It's not limited to video. It's not limited to a name or a special number used for identification purposes on identification documents. It could be somebody's voice print or their iris print or their fingerprint. So there's a lot of different ways that a person can be identified, and the law is written very broadly. It doesn't apply to persons who have passed away or are deceased. And in this way, it can be contrasted with copyright. So it's not a right that gets passed down into another generation in the same way that copyright can be. So a data controller, as we saw before, would, talking about scholars, they can't collect or disclose personal data unless the data subject, the person being videotaped or recorded, has given consent prior or at the time of such collection. And that permission needs to be made in a written statement or an electronic means, unless it can be done. It can't be done by its nature. The data subject may withdraw their consent at any time. And this makes it a challenge for dealing with the scientific record or the cultural heritage record. And at what point does a preservation institution deaccession their materials is a challenging question that we as archivists must deal with. The collection of personal data shall be limited to the extent necessary in relation to the lawful purpose of the data controller. So this speaks to the specificity that scholars need to write into their permission statements. The rights of the data subject are to obtain a copy, to erase and destroy, and restrict the use of personal data. So these permissions or rights to do these things, this is not all of them. The full law is like 39 pages, but the rights there can be changed, or the agreement can be changed after the initial agreement. So this means that scholars might need to be engaged with their data over a longer period of time, or be prepared to, or have the support and infrastructure and the tools to do that. The data controller then has the duties to have a system for erasure and destruction of data, and notify the Thai office that oversees the law if there is a data breach and there's a type of access that was not originally designed. So when that happens, how that happens, is beyond today's discussion, but there are some interesting exemptions. I want to quickly just touch on these just really quickly, that can possibly apply to cultural heritage contexts. If the materials are document are produced for the achievement purpose of relating to the preparation of historical documents or the archives for public interest. Now, as far as I know, the definition of public interest may be broad, but it's not clear from the definitions inside of the document. Now, I'm working with an English translation, and it's an unofficial translation, but and perhaps maybe in the Thai, the one written in Thai language, it's more specific, or it has some legal nuance that I'm not picking up in the translation. But for the purpose of relating to research or statistics in which suitable measures to safeguard this data subject's rights and freedoms are put into place in accordance with the notification prescribed by the committee. So this seems to indicate that there may be some extra guidance coming from the committee at some future point in time that we're not aware of yet, or at least I'm not aware of. So there are some exemptions then, and number 2, for preventing or suppressing the danger to a person's life, body, and health. Oftentimes, we could think of the materials that we produce as providing a healthy relationship for the people for flourishing in their language, especially in the context of endangered languages, where the working with a community to build up their language and support them in their language goals is actually supporting their community. And so it's bringing health and vitality to their community. A very interesting exemption in here for sharing personal information is that actually sharing the personal information is required in the process of executing a contract around that information. And so the examples I've heard is, well, you know, personal information might be some information like an address on a letter, but the postmaster or UPS or the person delivering the letter must use that personal information to perform their services to deliver the information, the letter. Well, it's kind of, in one way, Creative Commons licenses are like this, right? So Creative Commons licenses are applied to a material by the owner, and if the data subject is also the owner, and they're licensing that, then the archive is then given the permission to distribute that according to the Creative Commons license. And so, and almost a mandate to also redistribute under certain versions of those Creative Commons licenses. So it's potentially there that if under certain circumstances, it would be implied that sharing that information would be part of a copyright license. But I'm not saying that's a fact. Then there's also certain exemptions, which I'll touch on here in a minute, for nonprofits and foundations. And we see this type of exemption in U.S. privacy laws too at the state level. So one of the things here in this Thai law is that when these nonprofit bodies are making these resources and taking personal information, it doesn't. Our archives are often structured as nonprofit bodies in the United States, and I assume this is maybe the case in other parts of the world as well. But when an archive as a nonprofit body takes materials and delivers those interpersonally or those personal data more broadly, then the law says they can use it within their purposes. But if the purpose is to share that more widely, I'm not quite sure if it's inside the law's scope or outside of the law's scope. And so there might be some reason for clarity in this part. But there also may be some legitimate, shall we say, wiggle room for archives to do their designed purpose here. So this is going to be an interesting area to watch to see how it further develops. I mentioned the copyright component. So this is an illustration of the way it would work, is that the copyright holder would be on the storyteller, and they license it, and then the other recipients, because it's licensed, are able to do something with it. And it works if the copyright holder is the storyteller. It might not work as clearly when the copyright holder is the university or the scholar, the data controller. So in conclusion, I just want to say that privacy consent is moving forward is very important to document, along with the resources that are created by scholars in Thai contexts or working with Thai nationals outside of Thailand even. Production roles in the video of those resources are going to be important, and archives must have a deaccession process for content not licensed by the data subject. So thank you very much, and anticipate your questions.
Hugh, we're going to jump into your second presentation first.
Hello, my name is Hugh PATERSON, and I'm a scholar at the University of North Texas and the University of Oregon. Today's presentation is a comparison of Thai and United States copyright laws as they apply to scholarly video resources. It's one of the presentations presented at the 27th Southeast Asia Pacific Audiovisual Archive Association Conference. Thank you for joining me today, and I'm happy to take questions at the end or via email later, even after the conference is over. My main points today are what I hope that we take away from this discussion is that the recording of jurisdiction of copyright is important to our archival records, and as is the production roles of who produced the video resource and the employment relationship that those individuals have when they produce the video resource. These are often overlooked in scholarly resource production as part of the production of academic research. So, and that's my general context. So as a disclaimer, I want to say that this is not legal advice. I'm not a lawyer. I study legal frameworks, but lawyers often say, don't listen to anyone on the matter of copyright who is not a lawyer. Well, okay. That has some merit, but my understanding is that as archivists and as scholars and as archive managers and preservationists, we need to understand some of the intricacies of the legal frameworks that we deal with to help us better perform our duties and to be the good stewards that we need to be in the institutions that we serve. So why are we interested in copyright? Well, we have sometimes some internal motivations and sometimes some external motivations. Some of our internal motivations is that archive managers, we want to avoid legal obligations. Becoming ensnarled in a legal dispute can take up time and resources where we might better put those to use somewhere else. So it's a risk mitigation strategy. And sometimes we feel a moral obligation, maybe to the creators or to the participants in the production of the video. And so we want to steward that well through the use of copyright. Sometimes we want to know about copyright because we feel maybe there's an injustice going on, and we want to make some changes or participate in the change process happening for our legal jurisdictions, and so we need to know something about copyright to affect change in our context. Sometimes we just rely on copyright as a basic policy for distribution and access control. So those are some internal motivations. For external motivations, sometimes we are just told to record the copyright, and that's the end of the discussion. And that's just because we work at an institution that has this policy, and we just follow it. Okay, that's fine. There's nothing wrong with that. And sometimes as managers, though, we have a fiduciary duty to the content creators. We want to steward their resources well, to the donor, to the archives, the donors to the archive. We want to, show good stewardship practices, and so we have these other kind of outside pressures motivating us to understand copyright a little better. So, what is copyright? Well, from a U.S. perspective, it's kind of like this. Things exist, and creators should have the potential to make them and make money off of them more than anyone else. Then, as a government, often the governments come in and they say, okay, we will give you these privileges and then help enforce them. And so they create a copyright framework. And my illustration of this is kind of here on the slide. Is that all works exist in the public domain in time past, maybe in the future. So the public domain is kind of this conceptual category that's like underneath everything. And then certain protections are applied to certain types of materials. And those protections are copyright. So, for example, and those can vary by jurisdiction. For example, in Thailand, copyright is a little bit shorter than in the United States in general. And so, and this is one reason why recording the jurisdiction of copyright is important. There are certain categories of resources like government documents, which are completely outside of the scope of copyright, and they don't apply. And both Thailand and the United States have this category, so, and apply it to government documents. And by way of historical context of Thai-US copyright, the discussion has often been largely contextualized in the discussion of Hollywood and large movie industry participants who have a lot of money invested in video resources. One example of this is some trade, the special recommendation submitted to the United States Trade Representative in 1998 suggested that $19 million worth of infringement for just video resources was in that year alone. And following trade recommendations had different kinds of numbers and mixed numbers and categories. So, but it's been a long discussion in the academic and policy literature that it's been felt there's been certain piracy or infringement situations. But I think one of the things that's really important for us as archivists to look at is that Thailand, its legal, its government, and has updated its copyright laws in the last couple of years, and I suggest that it means that there's change happening there, and this change is probably a good thing as Thailand is looking to engage with new international partners, or and one of those is international treaties that kind of dictates the terms of copyright law is the WIPO Copyright Treaty. And this went into effect last fall, which was 2022 in October in Thailand. And it meant that Thailand needed to change some of its laws to become compliant with the treaty. And that's what happened earlier in 2022, and then it went into effect in October. My context is scholarly resources, video produced as part of a research project, often ethno-linguistic, ethnographic, oriented cultural heritage documentation via video, video used in language documentation. And these kinds of resources, some of the very interesting questions that we have to deal with are the works created as part of a work for hire scheme? That is, oftentimes this type of arrangement will change who the copyright holder is. And do the works meet the threshold of creativity for copyright applicability? So if a work, we might assume, as the law in both the United States and Thailand suggests, that it applies on creation or first publication immediately. But if the resource is not a creative work that is covered under that type of legal scheme, then it's not the copyright can't apply to it. So because, and the third very interesting question is that because copyright expires at the end of its term, is it really the vehicle that is most appropriate for those who are seeking agency over the materials? Oftentimes the materials that we produce are certain ethno-linguistic minorities want some sort of to become part of the process of dissemination and have some sort of control over that, and be in that conversation. And so oftentimes simply looking at copyright is not the solution that covers all the interests involved. So let's just kind of look at what the law provides here in Thailand versus the United States, and just those two comparisons. Now, the Thailand legal system is a civil law system, whereas the United States system is a common law system. So the civil law system often looks at the law first, and whereas the common law system will say, okay, the law, how has the law been interpreted by previous court cases, and how do those court cases apply to this situation? So the evolution of law and the way that it's approached is different in the two different frameworks of the two different countries. Another big difference between the two countries is the term length, which in Thailand's life is 50 years for most entities, or if it's a organization, then it would be 50 years after the first publication, where term length in the United States is a couple years longer, 25 to 45 years longer. In both countries, it's assumed that copyright automatically applies. Now, within the Thai framework of copyright, there are moral rights and neighboring rights. Now, moral rights is the right of the author to be acknowledged in their work, and neighboring rights would be sometimes called performer rights, are the ability of those performers performing perhaps a musical piece or in a play or a performance of some kind, that they are acknowledged and that the use of the materials do not damage their reputation. So those things are not protected in the U.S. framework. So understanding where the copyright is registered and if those moral rights have been exerted or performers have been documented is important as we produce materials. So some of the terminology is different between Thai and the U.S. So I'm just going to quickly go over this and summarize it in a third slide here. In the English translation of the Thai text and legal text, they use the terms reproduction and adaptation, communication to the public, and the letting for hire. Now, these are the things that copyright protects, right? So it allows us to give the benefits to accruing the copyright to other persons and license the rights. So these are the nitty-gritty of the copyright. In the U.S., we legal documents, we use different terms. So we have reproduce, derivative work, distribute, perform, and display. and authorize others to execute these rights. So let's just summarize that here. Reproduction or adaptation is very similar terminology to reproduce derivatives. Communication to the public is essentially what is meant to or equivalent in distribute, perform, and display. Letting for hire and giving benefits and licensing rights is very similar to the U.S. concept, or as described in rights to authorize others to exercise these exclusive rights. All right. Now, in the scholarly context, oftentimes the producers of resources want to share this broadly without requiring people to pay for the resource. And sometimes, so they want to freely distribute those rights. But the challenge then is that copyrights apply automatically. So they have to, in a way, be repealed on a per item basis. So how can we do that? Well, the Creative Commons licenses give us that vehicle, that legal tool to be able to say, well, the distribution of this resource is allowed until the copyright term is out of date, right? But in order to know when it's out of date, we must also know the jurisdiction, and that's not what's not always recorded. So Creative Commons licenses allow for the citation of creators. They allow with options for no derivatives, options for no commercial activities, options that the resource and or derivatives must be shared under the same license. So if you get something and you would have to, and you remodify it, then you would have to share what you remodified under the same license. Now, if you want to get not have any of those and you just want to put your resource in the public domain, then there's a public domain dedication. So, like I said, recording the jurisdiction of copyright is important to archival because we need to know when do Creative Commons licenses end. And when do the resources enter public domain? Because those sorts of questions impact our ability to manage resources as archival stewards. So recording the jurisdiction of copyright is important to an archival. And this is the essential conclusion then that I hope that we take away is that when we record video resources, we need the production roles, the relationship, employment relationship, and the jurisdiction of copyright. So thank you very much.
Thanks very much to Hugh. So just give us a moment and we'll just set up the Q&A. Okay, so we have Hugh and Bronwyn. So does anyone have a question that they'd like to kick off with? We might type the question for Hugh.
Yes. Hi, Rebecca. This question, I suppose, would be for Bronwyn. I wanted to ask, now that we are doing a lot of interdisciplinary work, say in the case of an exhibition that displays both commissioned works, plus often works, or in genre works of other things like visual art and that incorporates audiovisual material. Would fair dealing then come into play for that particular exhibition if you're unable to clear the rights for certain things? Because in Singapore we use fair use, and the recent copyright update has actually given archives and museums, everybody within the GLAM sector, a lot more ability, I suppose, to use fair use. So I'm wondering how, if as an archive, would you, I suppose you're working within the fact that you don't utilize fair use, but say in Singapore or in the archives within the region where we do have that ability to alternate between, how do we sort of manage that? I suppose that would be my question.
That's a really good question. For an exhibition, it would be really difficult, I think, to apply one of the fair dealing purposes. In addition to that, it's one of those uses that might have a negative impact on the NFSA's reputation. So in that instance, we would rather get permission and actually work with the copyright holder, like take it as an opportunity to bring them in. Maybe there's something they can add. We could do, recently we thought about doing additional interviews with creators to kind of, be a piece of the exhibition. So it's actually one of the reasons why fair use would be great. However, personally, I'm not a fan of fair use just because of how it's incredibly difficult to apply, and because of the really bad case law in the US. So it's really tricky. But it's one of the things where when we kind of go in and make a case for reform, it'll be something like, in my dream, we get an additional fair dealing purpose that is for cultural institutions, like an identified purpose for cultural institutions to use collection material in their, actually some really good words would be in fulfilment of their legislative responsibilities. So then it's broad enough to allow us to make a number of uses, but it's specifically tied to what our enabling legislation tells us we have to do. So it's kind of a nice, that would be like a dream clause, and I think it would help us around those issues, With orphan works though, we would use them under the flexible dealing exception,
Thanks very much. Yes.
What about things like TikTok? And I just say that because I'm sure, and Bronwyn, this is probably to you, I feel like I've seen on, I feel like I've seen on TikTok the Australian Broadcasting Commission, and it could be the NFSA, playing old newsreels. So does that come under kind of sharing news? And where does that impact anything? Because it's such a great way, I guess I'll say before you answer, it's such a great way to share the collections, and it's really exciting as historical content being shared on contemporary platforms. And I'd just kind of love to hear if there's any tensions there.
It's a really good question. With the ABC, and it is the ABC, they own copyright, so they can do what they like. So they make really good use of it. The NFSA could do that with that portion of the collection that we hold rights in. Otherwise, we would need permission to use third-party copyright in that form. But, that's something that's pretty easily negotiated because it is such a, everyone's using TikTok. So it's definitely, it can be negotiated on a case by case,
Yes, I have two questions. The first one for Bronwyn from the National Archives of Australia. I'd like to ask, if you have any exclusive framework, copyright framework for the Aborigines or Indigenous people in particular. And the second question, I just like to share experience with Hugh as the language documentator. I'm a scholar studying a project. I feel it's sometimes so hard to apply copyright to the framework to the fieldwork, because sometimes I interview the marginalized and ethnic minority groups who has trauma about giving consent or give a signature, things like that. They have a past about those things that give them negative effects Yeah, so if you have any advice, now I use verbal consent, but I still find it very hard to deal with it. Thank you.
Oh, sorry, we're just trying to get audio for Hugh as well, so he's having trouble hearing the room. So we'll come back to Hugh in just a moment.
All right, so I'll answer the first part. Yeah. You know, the Australian Copyright Act doesn't have an Indigenous cultural or intellectual property clause at all, so those rights are not recognised. There is some work being done on different aspects of Indigenous cultural and intellectual policy property. We call it ISIP. It's easier. So there's work being done. It's just started actually, and it's about protecting Indigenous artworks from being ripped off, basically. So it's starting in that visual arts field. But I do think there has to be something inserted into the Copyright Act soon. Like, it's just way too long with no protection in there. So those kind of cultural rights at the moment don't have any legal standing in Australia. Cultural institutions, and again, NFSA is one of the leading cultural institutions where we have our own ISIP protocols and our ISIP policy, and we work very closely with communities with material. So we're trying to do the right thing, but it's all on a policy basis rather than a legal basis, which is a real shame. There's also another interesting part, like the fair dealing exception for giving legal advice. So it's very much the Western construct of legal advice. So my team recently had a request from a law woman from one of the areas in New South Wales, and she wanted to get access to footage about her home, her lands. She wasn't the copyright holder, and we couldn't provide that to her without permission of the copyright holder. And in this case, that was quite tricky because it was over a demarcation dispute with the land. If Indigenous law people were recognised in the Act, then we could have provided that in the same way we could to a lawyer. So, yeah, there's a lot of work to be done.
Thanks very much. And yeah, apologies, we're still, poor Hugh can get the chat, but he's not getting the audio, so we're just trying to work that one out. Any more questions? Cool. Yep, thank you.
Sorry, I just had another question.
Given that NFSA is looking into the use of AI and into generative content, how does that work with the existing copyright law, and how are you navigating that?
I hate AI and I wish it just would go away. I was talking with Donna about this yesterday at lunchtime. The investigation about copyright and AI is really kicking off in Australia now, and everyone's looking into it. But I was thinking after our conversation, Donna, like, if machine learning is taking all that information from all over the place and it's pulling it together, then that's not a single, how can that be? This is literally just off the top of my head, right? So don't, this is what she said. How can that be a protected work? It's really kind of interesting.
I suppose, would it be considered a new created work? Could it be argued in that form? And I suppose then it's just that whose rights would whose right would then encompass, right, that new creation?
Yeah, exactly. I just can't see how can that be protected. Like, so if you think about what's required for copyright protection in Australia, it's that original character or effort. I don't know if pulling learnings from all over the places together is that? I mean, I'm not a lawyer either, I should say, but I know that a lot of lawyers are looking at that, and there'll have to be some kind of recognition in the Copyright Act for it because it's everywhere, but it doesn't make sense to me that that could be protected as a new creative work. But I don't know, it's, yeah.
Thank you. Okay, we're going to try and see whether we can get Hugh to speak, but I'll need to type a question for him or a commentary for him. So, particular queries for Hugh? Or actually, Kaszilawati seems to have joined too. We might have the same audio problem, but we can give it a go.